Hello and welcome to our Spotlight video series where we discuss cutting-edge employment law issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, where we help people who've been fired or afraid that they might be. I'm thrilled to be joined today by Sarah Basil, who is a law clerk in our office. Thank you, Sarah, for joining us today.
Thanks for having me, Tom.
So what are we talking about today?
We are talking about the latest Supreme Court decision on religious accommodations in the workplace.
Okay, so what do you think about that and its implications for employment law?
Yeah, so this case was actually just released, or the decision was released last week. Basically, it's about a USPS worker who's a Christian worker who wanted to take Sundays off, but USPS wanted him delivering packages on Sunday. So it kind of clarified the standard of what a religious accommodation, how much of a burden a religious accommodation can be on the company. And basically the Supreme Court ended up siding with the employee here.
Okay, and this was was this a Title VII case?
Yes, a Title VII case.
Okay, and what did they change the balancing test at all? What did the court say about how this should be applied by lower courts?
Yeah, they basically said that they kind of heightened the standard. So right now, or I guess before this decision was released, it was kind of hard for employees to get religious accommodations at work because the standard used to be that if it created some kind of trivial burden to the company, then it was allowed to be denied. But this decision basically, well, we think what's going to happen, or at least what I think is going to happen, is I think it's heightening that standard, so making it harder for or employers to deny any religious accommodations. The standard used to be what's called trivial, and now it has shifted to substantial burden. So it definitely heightened it.
So it has to be a substantial burden on the employer before the employer can deny the accommodation or the request?
Exactly, yes.
Yeah. Yeah, no, I think it's a fascinating case, and I think that case in conjunction with the case that came down about the graphic designer, where this graphic designer said she didn't want to design something for a gay wedding, and said that that the government shouldn't be able to compel her speech, which is a big difference from the way the law had been applied, because she opens a business, right? It used to be that if you open a business, you have to serve whoever comes to you, regardless of, you certainly can't discriminate against them on the basis of protected class. That was not an employment decision. Obviously this one is, but I think, the court is clearly signaling, and again, in that case, the court didn't decide it on the basis of religious freedoms. They decided on the basis of First Amendment free speech rights. But I think that case, in conjunction with the, this case with the postal worker, we see a court that is providing, I think, much more latitude for and protections for religious expression in the marketplace and in the workplace. So I think you're right. I think, and for, we represent employees, so I think and we see these claims not infrequently. So this is going to give, a lot more leeway for employees who want to request any kind of religious accommodation, more fodder to do that, because as you mentioned, Title VII for decades has had a balancing test for when does an employee, when they request a religious accommodation, when can an employer essentially say no? We don't care what your religious beliefs are. Not that we don't care, but it impacts our workplace, and here the court's opening the door a little wider for employees. So I think we're going to see a lot of litigation over this, right? Because anytime you have yeah.
And another thing that's really interesting about this case is that it was a completely unanimous decision, which I feel like you don't see a lot these days.
Yeah. That's a very good point. I mean, the graphic designer case was I believe a 6-3 opinion, and was hotly contested. We had some really strong dissents, and in this one it was a 9-0, which for this court in particular is unusual. But I think that will also send a signal to lower courts that there's not a whole, not that there's not ambiguity and room for litigation. There, there often is, but the court's sending a pretty strong signal with this opinion. You don't see a chink in the armor or some way to try to kind of roll this back.
Mm-hmm.
So, anything else you want to talk about that case?
I think those were the most important points that we hit on.
Yeah. Well, good. I appreciate you bringing that one up. It is going to be a big one for employees and for employment lawyers generally. So, appreciate you highlighting that one for us today, Sarah.
Of course.
All right. I'll let you get back to the next thing on your desk.
All right. Thanks, Tom.
All right. Take care. Bye-bye.